Thank you for that lovely introduction, Renee. My name is Theresa Tebbet. I'm an assistant district attorney in the Nassau DA's office. Currently, I am the executive director for our Office of Core Services, which is our victim services, our school-based intervention programs, a lot of our community outreach efforts. I'm the former chief of the Special Victims Bureau under DA Singas. So my topic today is the intersectionality of drugs, mental health, and sexual assault. And we have a lot to talk about. So I would like to frame it for you like this. The scope of the issue is that adolescents and young adults, so we're talking middle school, junior high, high school, college, are at the highest risk of any age group of being sexually assaulted. And we know that alcohol or drug use immediately preceding sexual assault was reported amongst more than 40% of adolescents, and in approximately 30% of sexual assaults that were reported by undergraduate females. And on some college campuses, that number can be as high as 50%, according to a study that was done by the National Institute of Justice. And I'll share with you a couple of statistics, not a lot, but one that I found particularly significant was the Association of American Universities released a study in October of this year that they did after a survey, which was described as the largest survey of its kind. And it was a survey regarding sexual assault and sexual misconduct at 33 major universities. And we're talking about universities like Georgetown, Johns Hopkins, UVA, Harvard, Yale, Brown, UPenn, MIT, Carnegie Mellon, Ohio State, Texas A&M, UNC, the University of Florida, and several other schools. And the results of that survey were that 1/4 of undergraduate women said that they'd been the victim of sexual touching or penetration without consent since starting college. The number was 25.9%. So when you think about all of those schools, right, some of the best schools that we have in the country, and that's a pretty staggering number of 25% of undergraduate females said that they had been the victim of some type of sexual assault. But we also know that only approximately half of high school age victims ever tell anyone about being sexually assaulted, and that number comes down even lower to only about 10% ever report to law enforcement. Male victims, and there are male victims, are even less likely to report than females. And when victims know their perpetrator, they're even less likely to report to the police. And we know that in almost 80% of cases, the perpetrator is someone that the victim knows, whether it's an acquaintance, an intimate partner, a family member. So if you think about how many cases then of sexual assault amongst adolescents and young adults actually come to law enforcement, actually report to the police and have a case initiated by the district attorney's office, think about what a small percentage of cases that actually is that we get to investigate and prosecute. We know that there is a severe underreporting of sexual assault cases, adults and young people. That tells us then that many victims are left untreated for all of the issues that they're dealing with as a result of being sexually assaulted. And it certainly sets up a lot of challenges for us as prosecutors when we do have a case that's brought to us that we're looking to file charges. The use of alcohol and drugs is a risk factor for perpetration of sexual assault. Perpetrators may intentionally drug their victims to be able to commit that act of sexual assault, or more commonly, we see, they may just take advantage of the vulnerability of somebody who was voluntarily intoxicated or voluntarily ingested some sort of drugs that had one of those sedative effects that you just heard Officer Oberthorn talk to you about. So that brings us to the issue of consent, right? Because sexual conduct without consent is sexual abuse and may implicate criminal charges. The use of alcohol and drugs can affect a victim's ability to consent to sexual activity. And consent has to be affirmative, right? So when we're talking about issues of consent, whether it's on a college campus or in high school or amongst our students, this is the messaging that we teach them, right? Under the governor's legislation for colleges, it's yes means yes. Consent has to be affirmative. So the question then becomes, did your partner know, did you communicate to them that you were agreeing or not agreeing to engage in some kind of sexual contact? Somebody who's too drunk or high to control their own conduct, can they actually consent to sexual activity? Someone can't give consent to sexual activity if they're sleeping or they're passed out, or maybe they're so impaired by the effects of some kind of intoxicating substance. But the law is kind of the flip side of that, the penal law in New York. So the law in New York is we have to prove a lack of consent. No means no is the standard that we have to use. No doesn't mean convince me. No doesn't mean help me change my mind. And that lack of consent has to be communicated. That's something that we have to have evidence of if we're bringing a criminal case. And it has to be an actual lack of consent, not just, well, in my head I was saying no. In my head I didn't really want to take that next step. Those are hard questions that we have to ask victims when we're interviewing them or if we're doing an investigation with law enforcement. And particularly for young people, this is where we see a struggle, right? How did you communicate? How did you communicate that you didn't want to take that next step or you weren't comfortable with that level of engagement in sexual activity? I've sat across many young girls, unfortunately, who would say, but in my head I was screaming no. In my head, I was screaming, I don't want to do that. In my head, I was screaming, I'm in over my head, I want to get out of here, but I don't know how. But without that actual communication of no and lack of consent, we're in a bind, right? We don't have the evidence of the lack of consent that we need to be able to allege and prove with a criminal case. But then we have to ask ourselves the question when we're talking about substance use, substance abuse, whether it's drugs or alcohol, how can someone communicate that lack of consent if they're too intoxicated? Or they're so impaired by a substance that they don't have their right mind about them and their verbal communication may be impacted? Or if somebody's passed out and just unable to speak or communicate at all because of the effects of the substance that they ingested. So this really becomes a challenge for us in law enforcement to be able to proceed with criminal charges where we have to allege and prove that lack of consent because the sexual conduct has to occur without lack of consent. So the law does give us some avenues. The penal law prohibits sexual conduct with somebody who is legally incapable of providing consent due to one of these factors. This is what's written into our penal law. So somebody who is less than 17 years old, doesn't matter if they said yes. Doesn't matter what they said. The law deems them incapable of consenting to sexual activity if you're under the age of 17. People who are mentally disabled or mentally incapacitated or physically helpless are also deemed incapable of consent under the law. And those terms have their own special definitions under the law. So it's not just what we commonly might think of mentally incapacitated or physically helpless. It's what the law defines those terms to mean. So the law defines mentally incapacitated as somebody who is rendered temporarily incapable of appraising or controlling their conduct, temporary because of the effects of a substance, owing to the influence of a narcotic or intoxicating substance that was administered to that person without their consent. Right? And that's significant for us as lawyers, as prosecutors, because what it doesn't cover is voluntary ingestion or voluntary intoxication. So we have to prove that somebody was actually administered a substance without their consent. That usually means they didn't know. So that's pretty tough for us. That's a big challenge. Has anyone ever heard this term before, drug-facilitated sexual assault? I see a couple of people. Okay, so this is what we're talking about when we're talking about sexual assaults that have occurred that involve the use of alcohol or drugs and the effect of those substances on the person who's being victimized in that situation. So drug-facilitated sexual assault is when alcohol or drugs are used to compromise someone's ability to consent to sexual activity, whether it's a perpetrator who uses drugs or alcohol to render their victim unconscious or semi-unconscious, or drugs or alcohol are affecting a person's ability to resist, and even affecting their ability to remember the assault. And these are some of the common drugs that usually come to mind when we're talking about drug-facilitated sexual assaults. Date rape drugs, has anyone ever heard that term before? The most common one that everybody thinks about is, oh, roofies, right? Rohypnol. That's a powerful benzodiazepine. GHB is another one, which is a central nervous system depressant, which we just heard about. And it's used specifically for its sedative effects. Ketamine, an anesthetic, a dissociative anesthetic. Soma, another central nervous system depressant. We also see all of those substances that Officer Oberthorn talked about in his presentation. So whether it's things that people have prescribed to them or in their medicine cabinet for sleep aids or muscle relaxers or anxiety medications, all of those are drugs that can be used for not their prescribed purpose, right? Not what maybe they're in the medicine cabinet in someone's family home for, but can be used because those effects on a particular person can render them incapable of resisting a sexual assault or render them just completely unaware of something that's going to happen to them or take place. But the most common drug that we see used in drug-facilitated sexual assault, anybody want to take a guess what it is? Yeah, it's alcohol, right? Maybe you're not so surprised by that based on the presentation that you just heard. But that's the most common drug that we see. Nearly 90% of the time, the drug that's used in a drug-facilitated sexual assault is alcohol. And that's according to the Department of Health and Human Services. But what does that mean for us in law enforcement? What are some of the challenges, particularly when we know alcohol is the most common drug? It's not prescribed by the law specifically. Under any of our statutes that criminalize sexual assault, whether it's rape, sex abuse, coercive conduct against a child, alcohol is not specifically prescribed by the law, and if it's a voluntary ingestion of alcohol, voluntary intoxication, it's not covered. So it's kind of a loophole in the law in that it's not specifically delineated as one of the factors. But what are some of the other challenges that we may face? Very often, a victim is unable to recall and describe what happened to them, right? And that's the most obvious challenge that we have. So too many times we've been in a situation where somebody comes forward to say, I was in a situation out last night with friends at a party, in a bar, you know, wherever it may be, and I remember point A, and I remember point C, but I don't remember what happened in the middle, point D. I know something happened. I woke up in a strange place. I don't remember how I got home. I don't feel good. Something hurts. And I remember being with a particular person, and I don't know what happened after that. There's a gap in somebody's recollection of what happened. And if that's when the sexual assault took place, who can tell us that? Who's our witness? Right? Who's our witness to describe a sexual assault occurred? Most sexual assaults don't happen in broad daylight. They don't happen in the middle of the bar or a party where other people can see, right? Think about it. They happen in secret. They happen in a bedroom upstairs at a party. They happen in a car. They happen in an apartment or a home that somebody has gone to after they've left their original location. So who's our witness? If our victim, who's normally our best witness to say, this is what happened to me, now is saying, I don't know what happened to me. I don't remember what happened to me. I remember only bits and pieces of what happened to me. That's a big challenge because we have to prove that sexual conduct took place, right? Whether it's intercourse or whatever type of sexual contact it was, we have to prove that with specificity. That's what the law requires. So it's difficult. We may have victims who have some memory, but there are gaps in that memory, so they don't necessarily know the extent of the abuse or the sexual contact that happened. And that's all because of the effects of the drug. A lot of those drugs have amnesia effects, and that's why they're used. And sedative effects. So If you think about if you're prescribed a sedative, its intended effect is to sedate you. If you're taking that unknowingly, or you're being administered that without having any knowledge that that drug was put in your drink or slipped to you somehow, then you don't even know what's happening because the drug is starting to take its effect and the sexual assault is occurring. So this is our biggest challenge in those types of cases. We have to have evidence of the administration of that drug. We have great difficulty in gathering that evidence, identifying that evidence. If a victim is not aware that they've been drugged, it's done covertly, there's no witness to it, how are we going to have evidence of that? The sedative effects of a lot of these drugs begin quickly. So a victim is not aware of what's happening to them as the drug is taking its effect and when the sexual assault takes place. They also dissipate quickly from somebody's system, from blood or urine. And because they are dissipating so quickly, we are literally losing the evidence before somebody even has a realization of what happened to them. Never mind makes the decision to get to a hospital or report to the police or tell a friend or a family member or something. The evidence is literally dissolving and disappearing before we even know sometimes that a crime occurred. So that's a big challenge for us. Some of those drugs only last in your system 8 hours or 12 hours, right? So if you have somebody who realizes what happened, makes a disclosure, goes to a hospital, reports to the police, and they attempt to take a sample to be able to test that, a lot of times it's just too late. And a lot of these drugs that are used are not in the standard panel of testings for labs across the country. That's not just a New York problem, that's an everywhere problem. So unless we make a specific request, test for GHB or test for XYZ substance, we're not going to have that in a standard lab test. So think about this. You have a victim who is not aware that they were drugged at the time that it happened. Something happens, they have a realization of it, they make a report, we are looking to do a test. They don't even know that something was given to them. So how can they tell that to a medical professional or law enforcement to say, by the way, I think I was given GHB, request that in the lab panel of testing? It's just unrealistic, right? So the law is setting us up for some real hurdles. The law also defines narcotic substance, something that's on the schedule of controlled substances. We're seeing the prevalence of a lot of synthetic drugs. The law has not caught up to some of those manufactured drugs, especially the ones that are coming from the internet or from China. You change one little ingredient or the amount of a particular additive to that substance, and it's no longer on the schedule of things that are prescribed as illegal. So we find ourselves in the situation that the people who are manufacturing the drugs are one step ahead of the law that exists, especially the ones that are coming on the black market. So the law also criminalizes sexual contact with somebody who's incapable of consent by reason of being physically helpless. And that term as well has its own specific definition under the law. Physically helpless is somebody who is unconscious or for any other reason physically unable to communicate an unwillingness to enact. This sometimes is another avenue that we can use to charge cases when we don't know what the substance was that was administered to somebody or that someone ingested that was used to incapacitate them. So for example, in cases where just a victim is completely passed out or they're in and out of unconsciousness during a sexual assault, or they're asleep because of the sedative effects of whatever substance they ingested. If anybody followed any of the news coverage on the Bill Cosby trial, some of those victims described a substance that they ingested that then had physical effects on them. So being awake but feeling paralyzed to move, or being in and out of consciousness but not being able to physically move their limbs or get up or resist. Things like that would fall under the legal definition of physically helpless in the New York law. And I'm going to give you an example of a little case study of a case that our office prosecuted a couple of years ago that highlights some of these challenges, and this case has what I would call a happy ending, and I'll tell you about it. But this is the case of the people of the state of New York versus Dennis Edison. This is Dennis Edison. This is his arrest photo. He was 31 years old at the time that he was arrested back in 2015. Back on November 23rd, 2015, we had two 21-year-old female tourists from Germany who were coming to New York, landed in here right before Thanksgiving. Great time, right, to be in New York City, see the Thanksgiving Day parade, see all of the holiday decorations. They had never been to the United States before, certainly never to New York City. But they used a website called couchsurfing.com. Has anybody ever heard of it? Okay. So if you're not familiar with what couchsurfing is, it's almost like a reduced version of Airbnb. You're literally crashing on somebody's couch, right, as opposed to renting a home or an apartment or a room. And that's where our two 21-year-old female German students met 31-year-old Dennis Edison. And we're going to crash on his couch in his apartment in Long Beach in Nassau County. They thought that he was close to New York City because his profile advertised him as such. They also thought that he was their age, in his early 20s. He was much older than that. And he described his apartment as being a short train ride into New York City. I don't know if anybody here is from Long Beach, has been to Long Beach. Is it easy to get from Long Beach to New York City? If you're a 21-year-old German tourist who doesn't speak English, probably not, right? So they felt pretty isolated once they got to his apartment out in Long Beach. And they were going to be here for about 2 weeks. And they were planning to visit the city from there. But he had a plan to wine and dine these two young girls. So during their second day with him, they had their own little private party at his apartment. He prepared cocktails for them. He claimed to be a bartender and knew how to make all sorts of fancy cocktails. He said he was a mixologist. But upon consuming the beverages that he had prepared for them, both of the girls started to feel some noticeable physical symptoms. They started to just feel different. Tired, sluggish, dizzy, really becoming unaware of their surroundings. One of the girls ultimately passes out and falls asleep on the couch in his living room, while he escorts the other girl into his bedroom where he had a massage table set up. And he offered to give her a massage on that massage table. She was told to lie down on the table. She did that and then promptly passed out. She wakes up unknown amount of time later. She's not able to orient herself to how much time had passed. And she awoke to a pretty severe cramping and aching pain in her lower abdomen, as she would later describe it. She went into that room fully dressed, woke up fully dressed, yet discovered when she went to the bathroom that she had some sort of massage oil on her inner thighs. And she could not offer an explanation for how that was because she had woken up fully dressed. She and her friend then start to suffer from violent vomiting for the rest of the day and most of the night. And by the next morning, when physically they feel well enough to be able to leave that apartment, they flee. They get on a train, they get into the city, they find the German consulate, they call their family back home. They end up at a police precinct in Manhattan, thankfully, and our particular victim went to a hospital in New York City where she was examined. So that's a pretty tight timeline of somebody realizing something has happened and making efforts to get help, make a report, make a disclosure. She's examined by a nurse at the hospital who swabbed her body for DNA samples and took note of a very large bruise to her cervix, which was probably the explanation for the pain that she was feeling in her abdomen. And DNA analysis was done on the swabs that were taken during her exam at the hospital, and they found semen on the swabs that were taken from her cervix and vagina. So, Dennis Edison was arrested, and he was indicted by a grand jury, and his case went to trial sometime in 2016. And we proceeded on the charges of rape in the first degree and sexual abuse in the first degree under the theory of physically helpless, because our victim was incapable of consent by reason of being physically helpless, the fact that she was passed out. She described that. She was able to describe that feeling. And she was able to describe the physical symptoms that she was experiencing. But these cases are often very difficult to bring because we still need evidence of the sexual assault. We had that here because we had semen that was found in areas of her body that you would not normally find semen unless intercourse had taken place, without being graphic. That's pretty great evidence for us in a rape case. We were not able to bring charges under the provisions for mentally incapacitated of somebody being under the effects of an influence because we didn't know what it was. We knew she had cocktails with alcohol in them. We didn't know what else was in them because all of her lab tests came back, quote unquote, clean. No substance was detected in any of those tests, which for us was not a surprise because by the time she left his apartment the next morning, took a train into the city, went to the German consulate, went to the police, and finally went to the hospital, we're talking about over 24 hours. And those substances typically don't last that long. But still a challenge in a case where that evidence would have been helpful to us. But this is the evidence that we did have. So we had the victim's testimony about the physical symptoms that she was experiencing before, during, and after her time in that bedroom with that massage table. We had medical evidence. We had the nurse who testified about the findings of the exam, both the injury and the process of conducting the exam and taking the swabs that led us to recover DNA evidence from the victim's body. We had a forensic biologist from the Nassau County DNA lab testify that the DNA from the semen on the swab that was taken from the victim's body matched the DNA from a swab that was taken by the police from the defendant. So we knew that he was the source of the DNA that was found on the semen that was found inside of her. So therefore, we were able to prove that someone had sex with her because we had semen inside of her, and he was that someone because his DNA matched the DNA that was found inside of her. And then we had this. We had a forensic toxicologist testify to give us an expert opinion. So remember I said her toxicology labs came back, quote unquote, clean, no substances detected. But we had a toxicologist who reviewed those lab reports, reviewed her description of what happened, reviewed the physical symptoms that she described, and was able to give us an expert opinion that those symptoms, that both she and her friend were experiencing, those physical symptoms, were consistent with somebody having consumed alcohol and GHB, which we know is a known date rape drug. So that's how we were able to prove that the victim was physically helpless at the time that the sexual assault took place, as a result, physically helpless as a result of the drugs and alcohol that she had ingested. And he was convicted of both the rape charge and the sexual abuse charge. He was sentenced to 10 years in prison, 20 years of post-release supervision, and that conviction was affirmed on appeal in December of 2018. So that was a good outcome for us as prosecutors on a case like this. But this is a unique case in that most of the time when we see a scenario like this, we don't have sort of all those other pieces of evidence line up as perfectly, really, as they did in this case. And we recognize that there are limitations under the law. There are limitations in our ability to bring a case sometimes. And that can be difficult for victims, right? That can be disappointing and frustrating that they're not able to seek redress from the criminal justice system for what clearly has happened to them, right? Too many times we are sitting across from young people and telling them, I believe you. I have every reason to believe you. I just don't have enough evidence to be able to bring charges. And that's disappointing and heartbreaking for them and for us, right, as prosecutors. That's difficult. But beyond law enforcement involvement, prosecution, convictions, somebody going to jail, there are significant mental health consequences for somebody who's been the victim of a sexual assault, particularly a sexual assault that happened to them without them knowing. right? That victim, in the case I just described, found out that she was raped when she was sitting in the ADA's office and the ADA was telling her, we have DNA results back. There was semen found inside you and the profile matches this person. She knew something had happened based on how she felt, but she didn't know the extent of the sexual conduct that had occurred, but now she knew, right? So imagine how that feels. It's horrible, right? It's horrible to realize that you've been violated and not even know. So when we want to talk about mental health and the intersectionality of substances, alcohol, drugs, sexual assault, and how that affects someone's mental health, certainly there are mental health consequences. And beyond what we deal with as prosecutors, it's something that you may see as educators, mental health professionals, parents, family members. These are the things that we know victims of sexual assault in general, but particularly drug-facilitated or drug-induced sexual assault are dealing with. Some of them, I'm sure, seem obvious to you. Feelings of self-blame, anxiety, confusion. Was this forced? Was this consensual? Particularly in the cases where the ingestion is voluntary, right? Because kids can drink, kids can take drugs. They shouldn't. It might be illegal, but it happens, right? Let's be realistic. We know that it's happening. That's why we're having a whole conference about it. How much of that is my fault, right? That's what a victim usually thinks. How much of this did I bring on myself because I put myself in that situation, at that party, with this person, ingesting this substance? Did I consent? They're saying I did, but I don't remember. I don't remember. So is this my fault? Is this not my fault? It leads to higher rates of depression, higher risk of suicide, and self-harm behaviors, things like eating disorders, self-mutilation. And experiencing all of these things and all of these feelings is a barrier to somebody disclosing and reaching out for help, whether it's telling a friend, telling a mental health professional, telling a trusted adult at school, telling the police, whatever it is. These are the things that we know increase somebody's reluctance to come forward with a disclosure. And that puts survivors or victims of sexual assault at a higher risk for substance abuse, trying to numb that pain, dull those feelings, forget about what happened by taking other substances. And they're experiencing that self-consciousness or confusion after experiencing the sexual assault. And we see this lead to an increase in other risky behaviors. So poor use of contraception in consensual sexual activity, a greater number of sexual partners at a younger age, a greater number of pregnancies, a higher risk of STDs, all of those things that can go along with that, that are putting our kids at risk. So what can we do to support adolescent survivors and their families, right? Because we can't just look at the adolescent in a bubble. These things affect their families as well. Just like drug addiction affects an entire family, an entire neighborhood, an entire community, so too does sexual assault. Survivors should be assessed for their mental health. Trauma-focused cognitive behavioral therapy has been shown to be effective in dealing with the trauma that somebody is trying to work through after having been sexually assaulted, particularly a drug-facilitated sexual assault. Educating parents to recognize and monitor for the symptoms of a teen or an adolescent who's experiencing depression, self-harming behaviors, suicidal ideations, all of those things. And counseling for the parents, certainly counseling for the adolescent, but counseling for the parents to encourage them, to encourage their child to get help, to talk about it, to avail themselves of resources, to let parents know what resources exist and are out there. And counseling for parents on ways that they can reduce potential access to means of suicide, whether it's removing firearms from a home, removing medications or access to those things from the home, because we learned that that's where kids are getting most of those substances, is in their home. And educating students. This is another big one. So prevention messages for both females and males, because it's very easy for us to overlook the fact that males can be victims too. We see it less in the cases that come to us, but the fact that we see it less and talk about it less just drives down the reporting of males who are victims, right? Because they're already so marginalized in these conversations that their willingness to come forward and make a disclosure is going to be greatly reduced if we don't include them in the conversation of people who are victims. So that's really important. Educational interventions for preventing relationship and dating violence. Like I mentioned earlier, 80% of sexual assaults are committed by a perpetrator that the victim knows. And it can often be somebody that they are in a relationship with, whether it's middle school students, junior high school students, high school teens. That's the person they consider their boyfriend or their girlfriend. What that means to them in this day and age may be different than what that term means to us as an adult. They may not be going out on dates, to the movies, or to get pizza. A lot of it is, well, we're texting, right? We have our own Snapchat group chat. And that's their boyfriend or that's their girlfriend, right? You guys, I'm sure, are seeing that in your schools. I have 2 teens, and I'm seeing it, and it's a whole different world than dating when I was a teenager. But educational interventions that talk about what is a healthy relationship? What is your right to exercise consent in a sexual relationship? Or to exercise your right to say, I don't want to be in a sexual relationship. Our office, the DA's office, has a healthy relationships program that we bring out to schools. We start as young as middle school. And the DA commissioned the Special Victims Bureau in our office to create that program about 1.5 years ago as a result of our Special Victims Bureau seeing cases with younger and younger victims on sexual assault cases. And it was not the typical case that we usually saw of an older family member sexually abusing a younger child in that family. It was a young teen with somebody that they identified as a boyfriend. That person was 25 or 30, but they met them online and thought that they were 17. If you're 13 and a 17-year-old is paying attention to you and wants to be your boyfriend, that can be pretty exciting, right? And you're communicating online and you're sharing pictures back and forth, and then finally you meet in person, and guess what? Surprise, he's not 17. He's not your boyfriend. He doesn't go to the school in the next town over like he lied to you and said that he did. We were seeing that happen very often, and we were seeing it because a sexual assault had happened when that in-person meeting finally took place. And the DA said, we have to do something, right? We have to reach these kids, and we have to reach them younger to let them know this is what a healthy relationship looks like. This is how to be in a healthy relationship in middle school or junior high or high school. These are the things to watch out for. These are the warning signs that maybe this is not a healthy relationship for you, and how to exercise your right to consent to engage in sexual activity or your right to refuse to engage in sexual activity. So we are doing that program in schools across the county. The Safe Dates program is another one, if anybody's heard of that. It's a 10-week curriculum that's brought into high schools. The Safe Center, I'm sure you all are familiar with, runs that program. Talking to our students and our kids and our family members that are young adults or adolescents on how to identify and avoid high-risk situations. So teens are hanging out. They're going to parties and whatever that setting may look like. But what is a high-risk situation in a setting like that? Don't drink from a cup that's been left unattended. Seems pretty obvious, but they don't know, right? It's stating the obvious, right, to our teens, because they don't have that cognitive decision-making and cognitive thought process that we have. Attending parties with people that they don't know, right? Meeting up with people that they've met on the internet that they don't know in real life. Is that person who they actually say that they are? Because they probably aren't. On our college campuses, walking alone at night, going out with a group and coming home with a group, looking out for each other. And bystander interventions. So how can we do this for bullying, right, in a lot of schools. Be an upstander, right? Don't be a bystander, but be an upstander. Speak out. If you see something happening, be able to speak out in defense of your friend, or to call out somebody who's engaging in, say, bullying behavior. There are programs for bystander interventions for sexual assault as well, right? So taking that message to our students, encouraging them to buddy up, to be a trusted source if somebody needs to make a disclosure or talk about a situation. So how do we handle cases like this in Nassau County when we have adolescent sexual assault cases? We have what's called the Child Advocacy Center multidisciplinary team. So this is a coordinated response with joint and comprehensive investigations with partners from different facets of the county. So it's the district attorney's office, the police department special victims squad, child protective services, the Safe Center, our medical professionals, advocacy professionals, and service providers. And the mission of the Child Advocacy Center multidisciplinary team is to collaboratively investigate cases of child sexual assault as well as severe physical abuse, to minimize traumatic exposure for victims and their families, to maximize information gathering and child protective capabilities for all of the team members, and to provide supportive services for child victims and their families. So the CAC physical location is a child-friendly environment. Somebody may be coming there for law enforcement to conduct an interview, but you're not going into a precinct and sitting in an interview room with a police officer in a uniform with a badge and a gun on their belt sitting in front of a computer. No, you're coming into a bright, decorated, child-friendly environment with beautiful murals on the wall, in a playroom full of toys, in a comfortable chair or a big beanbag on the floor, and it's more welcoming and it's more relaxed so that it's less stress-inducing when somebody is coming in, knowing that they're going to have to talk to us about a sexual assault that occurred. And those interviews are happening with trained forensic interviewers conducting the interview of that child. They are trained in a minimum of a 40-hour course that's certified by the state, using unbiased, non-leading, and legally defensible forensic interviewing techniques that are in accordance with the National Children's Advocacy Center guidelines. And that's really important because that's how the investigation stands up in court when we have a prosecution. Or if the county attorney's office, say, is bringing a neglect proceeding in family court because maybe the perpetrator is a family member or a parent or somebody who is legally responsible for that child. This is how we can defend the work that they do. Because what is the most common defense that you probably hear in relation to somebody disclosing a sexual assault? It's a false report, right? She's making it up. You don't have evidence, you don't have notes, you don't have witnesses, you don't have video. It happened many years ago. The child is lying because the parents are in the middle of a divorce, or the child is lying because they don't like Uncle so-and-so. Less than 4% of sexual assaults that are reported are investigated to be false reports. That's a pretty small number. But that's the most common defense that we hear. And it's very easy for people to perpetrate that defense when they say, well, you asked leading questions. The child was coached on what to say. They were told what to say. It was scripted what they should say. But when we do a forensic interview with one of our trained forensic interviewers, that's impossible. Because the way that they ask the questions and the techniques that they use, because that's how they're trained to do the interviews, stands up to those challenges. It's important for you to be aware of that, those of you who are working in a school setting, because we see a lot of cases that come in because the school has made a report. You're all mandated reporters, right? Because the school has called in a report because a child has disclosed something at school. Maybe they told a friend and a friend told a teacher and it's reported. Or maybe the child told a guidance counselor or a social worker at school and you have reported it as you're required to do. And of course, when a child comes forward with that type of allegation, everybody wants to ask the questions. Well, tell me about what happened. When did it happen? How did it happen? How often did it happen? Who did it? Who was there, right? It's better from our perspective if those types of questions and that line of questioning happens in this setting. Because then we know it's legally defensible. Then we know it's non-leading. People are certainly well-intentioned because our first instinct is, oh my goodness, you're talking about something terrible that happened to you, I want to help you. Right? I want to help you. Do I need to call the police? Do I need to call CPS? Do you need to go to the hospital? Do you need to see a counselor? Do you need a crisis intervention? But in a school setting, for example, those kinds of interactions with the person who's making the disclosure are better kept to like a minimal facts interview. Let's get the bare minimum of what happened so we know who to call. Are we calling 911? Are we calling the state registry? Are we calling for an ambulance? You know, how do we get immediate emergency assistance? But not going into all of the details of the interview and leaving that to the professionals at the Child Advocacy Center. Because if we are looking at this case with an eye of bringing a criminal prosecution and the police being able to do an investigation, that's helpful for us, more helpful, when we don't have non-professionals sort of doing an initial investigation before we get involved. So when a case is coming into the CAC, it's because either a report has come through CBS or maybe somebody has made a report to the police, whether it's a call to 911 or a call into the precinct, and the child is just brought right to the CAC, and they come with their family. They're assigned an advocate who will stay with them through the life of that investigation and that case and beyond. And the advocate is a source of support for them, is a source of information for them. If somebody needs a counseling referral, if they need a medical exam scheduled, whatever it is that that family needs, the advocate is kind of their liaison to be able to almost be their case manager, to be able to make sure all of those things are set up for them. When they're getting interviewed, one person interviews them in one of those child-friendly rooms, and it's recorded on video. And on the other side of a two-way glass are all the other partners on the investigative team. So maybe the interviewer is one of the professional forensic interviewers, and the team is a CPS caseworker, a detective, and a prosecutor. They're on the other side of the glass, able to hear in real time what's going on. So that child doesn't need to be interviewed again by the next person or the next person or the next person. The interview may take place. The interviewer will step out and ask the team, anything I need to follow up on, any other questions that you want to ask, right? Everybody's coming from their own perspective with their own role in the investigation, but we're having only one person do the interview, so it minimizes the number of different people that a child has to recount a traumatic event to and the number of times that they have to do it. So now we have that interview preserved on video. So if somebody else needs to know what the child said, they can watch the video. We don't have to bring that child in for another interview, right? So we're trying to minimize their trauma. If their case is going to court, the advocate may accompany them to court. If they have to testify, they're coming to the district attorney's office, to prosecutors in our Special Victims Bureau, who again are all trained as forensic interviewers and just trained in how to handle these cases. We have a facility dog in our office. If anyone has ever heard of a facility dog, Renee I know has met. Our facility dog is Mega. She comes to the office every day with the now chief of that bureau, and she's sort of a source of comfort to victims, to witnesses, to people who work in the office that are having a stressful day in court. But all things that we do, probably the people who work in our office use her more than victims do, I think, on some days, because our job is not easy sometimes. But she is just another resource that we have available, because the process of coming to court and having to testify is difficult, to say the least. When you're a child or an adolescent or a young teen and you're coming to testify about a sexual assault that took place, it's even more so. So we try to just do what we can to kind of minimize those negative effects. And there are resources that are available in Nassau County. I'll leave that slide up for a second in case anybody wants to jot it down or take a picture of it. Obviously, our office, Special Victims Bureau, is a resource. The Special Victims Squad of the Nassau County Police Department, again, all trained forensic interviewers, and all have gone through trauma-informed interview training and just trauma-informed training on how to deal with victims of sexual assault. The SAFE Center is probably the #1 advocacy and support service agency in Nassau County for victims of sexual assault, as well as intimate partner violence and child abuse. They have a 24-hour hotline. And then there are some national numbers up there. So RAIN is the Rape, Abuse, and Incest National Network, another resource. and the National Domestic Violence Hotline number. All ways that people can access services, particularly crisis intervention services. And like I mentioned, our office does have the Healthy Relationships program that we bring out into schools. We have other programs regarding drinking and driving, heroin and the opioid epidemic, as well as our internet safety and cyberbullying programs. So if any of you want more information on what those programs entail or how to bring them to your school, please don't hesitate to reach out to us, and we'd be happy to give you some information and schedule you for one of those presentations. And with that, I will conclude. Thank you.